Since July 11, 2024, that the Supreme Court delivered its landmark judgment on the fiscal autonomy and freedom of local government councils in Nigeria, there has been ongoing debate on the enforcement of the court pronouncement. Correspondent Kulujo in this report examines issues surrounding the implementation of the judgment and its implications on the policy. The report.
For the past 2 decades, funds allocated to states of the Federation and local governments from the Federation account are deposited into a joint account intended for both levels of government. According to Section 162 of the Constitution of the Federal Republic of Nigeria, 1999 Constitution, each local government is supposed to receive its rightful share from this account. However, many state governors have deviated from this system by either withholding this fund entirely or disbursing only a portion. This practice has caused significant hardship for citizens who are deprived of these benefits and services that democracy at the grassroots level should provide. However, the Supreme Court of Nigeria on July 11, 2024, in the case of the Attorney General of the Federation versus Attorney General of the Abia State and 35 others, the court reinforced the autonomy of the local governments in Nigeria, affirming their status as the distinct third tier of government. This significant judgment addressed crucial constitutional issues surrounding the financial independence of local governments.
The government commends and remains grateful to our apex court in the land, the Supreme Court of Nigeria, for living up to its status as both a court of justice and as a policy court in their landmark judgment that emancipated, liberated, and set free our local government system in Nigeria from the claws and shackles of tyranny and oppression of those who had held them by the jugular over the years, which has led to almost total stagnation and absence of development and governance in 774, almost all the 774 local governments.
Right from the time that the Apex Court made public its decision on this matter, mixed feelings and reactions have been trailing the implementation of the judgment, which majority of Nigerians believed will restore democracy to the grassroots. Not only that, aside from rushing to conduct local government council elections, it has been revealed that some state governors had come up with legislations to circumvent the judgment of the Supreme Court. Some legal practitioners spoke on the implementation and enforcement of the Supreme Court judgment in favor of the local government autonomy.
Such judgments must be enforced, otherwise the party cannot use it for anything, and it may become a pirate judgment. There's no doubt that the age-long law is that a judgment of a court subsists until it is set aside on appeal by a higher court. And that means it must be obeyed. So parties or government agencies cannot choose and pick or pick and choose which judgment to obey and which not to obey.
It's a Supreme Court pronouncement. It's a decision of the court, and it must be enforced by all persons and authorities in Nigeria.
The Supreme Court of Nigeria is the final court of the land, and that they cannot make a pronouncement that will not be enforced. So in other words, the Nigerian Senate stands solidly behind the Supreme Court decision.
Not minding the antics of the governors, the federal government has, however, issued a stern warning on the need to honor and respect the judgment of the courts, saying any violator is treading the path of contempt of court.
My simple comment is that the states concerned are advised not to tread within the precincts of contempt of court, and that my colleagues at the subnationals should not also invite what I will call the attention of the legal practitioners disciplinary committee for misconduct.
It is hoped that necessary machineries will be put in place to ensure strict compliance with the Supreme Court judgment and ensure the freedom of local government councils in Nigeria. Kunle Uju, Galaxy TV.